Welcome back to Court TV Live, about 3 o'clock in the east, about 9 o'clock a.m. out in Ohau. That is where we begin the hour in Hawaii for day 6 of the Gerhardt Konig attempted murder trial. Back in March, a year ago, basically, 2025, Konig took his wife Ariel on that hike on the Palipuka Trail in Oahu for her birthday. And according to Ariel, that is when that brutal attack took place. He allegedly struck her in the head multiple times. He also tried to, according to her testimony, pull out a syringe with some substance and tried to inject her. She was able to resist and knock that syringe away. A syringe was never found at the scene. Now, he was on the run in this terrain for hours, so he could have easily gotten away with it, or got rid of it. But there was no syringe found. We're waiting for the jury to report for duty on this day 6. They had yesterday off, a long weekend. And so while we do that, let's get you caught up on the case against Dr. Gerhardt Konig.
The point being, this is going to be a he said, she said trial.
The he in this case is Dr. Gerhardt Konig, an anesthesiologist, charged with attempted murder of his wife Ariel, a nuclear engineer. She's accusing him of trying to throw her off a cliff in Hawaii.
This is an allegation made by his wife, who has now filed for divorce and is seeking full custody of their young children.
36-year-old Ariel Konig told Oahu police her husband suggested that for her birthday they take a hike on a scenic trail. She says he brought her to the edge of a lookout on March 24th where he tried to push her off a cliff, and when that failed, prosecutors alleged that Konig made 2 more attempts to kill his wife.
He tried to stab her with syringes, and then he moved on to his third way of trying to hit her with a rock.
Ariel told police her husband first became enraged on their hike when she refused to take a selfie near the edge of a 1,200-foot drop. According to court documents, Konig yelled at her to come back when she refused. He then pushed her into the bushes, and that's when a struggle began. 2 hikers intervened after hearing screams for help. They recalled seeing Konig over Ariel with a rock. They say that is when he stopped. Police say 46-year-old Konig fled the scene, sparking an 8-hour manhunt through dense brush, and during that time, he FaceTimed his adult son.
He told his son that he tried to kill Ariel. Second, he gave his son the reason for why, that she'd been cheating on him.
Dr. Konig's attorney says this is not as one-sided as it may seem.
No syringes found on the hike, on the trail, anywhere near there, and you can bet your bottom dollar they searched that place very, very carefully.
Ariel Konig has since filed for divorce and initially obtained a restraining order claiming months of abuse, control, and jealousy leading up to the attack. The order was later dismissed, citing Konig's no-bail custody status.
Ms. Konig's doing well. She's still recovering. She still has some injuries, but she's spending time with her family. She just wants to get back to some semblance of her normal life.
Dr. Gerhardt Konig remains held without bail. He has pled not guilty. If convicted, he faces a lifetime in prison. And we're still waiting for the judge to take the bench. As soon as we see the camera move, we'll head into that courtroom and start the day of testimony. There's a live look inside the courtroom. It's the Konig ceiling tiles. It's kind of like the Karen Reed fan. We're getting used to it. No seal in this case. Let's bring in Kelly Hyman. All right, this is the state's case is moving along, and one of the most anticipated witnesses is the son, who allegedly Dr. Konig FaceTimed during the time that he was on the run. He was up in the bush. It took him hours, authorities, to actually take him into custody. During that period of time, the allegation from the state is he called his son, FaceTime, and said, "I tried to kill your mother." That's what the state's trying to get across. What the son actually says on the stand is going to make a huge difference, is it not, Kelly, when the jury is trying to determine what he allegedly confessed to in this conversation?
We are all waiting for the son to testify, because if in fact that's what he said, then it's a much, much stronger case for the state, because as defense attorney said, this is just a he said, she said kind of situation where the wife says one type of story, but defense is arguing something different. Now, in fact, here we have the son who testifies and says, in fact, yes, his father said that. But let's think about the family dynamics. Here is a son that could potentially has to testify against his own father. And what ramifications can that psychologically have on the son for the rest of his life, where in fact that potentially he's the person that makes his father spend the rest of his life in jail.
Yeah, and the wording will matter here. I got a fight with your with Ariel.
I can't hear him.
That's all right. Kelly can't hear us, but it doesn't. We'll forge ahead until we figure that out. Another part of this case, from the defense standpoint, is that Ariel was having this affair. And it's unclear to what level the affair was, but with this Mr. Miller at work. She's a nuclear engineer, works with this guy. They have a very tight bond. Nobody's contesting that. And that was a big part of the cross-examination of Ariel when she was on the stand. Let's take a look back and listen to some of that back and forth between the defense and the wife.
You said that he was bashing it against your face and head, yes?
Yes, sir.
He was smashing it into your head and face, yes?
Yes, sir.
Full blast, 100% of his power is what you said, yes?
Yes, sir.
And 10 times, yes?
I said as many as 10 times, sir. I wasn't counting.
Well, you told that to the detective. You told that to the grand jury. Correct?
Yes, sir.
Under oath, right?
Yes.
That it was many as 10 times, correct?
Yes, sir.
Your head, forehead, and eye is what you said, yes?
That's right, sir.
To your knowledge, you did not lose consciousness, correct?
To my knowledge, I did not lose consciousness, correct?
All right, so that was her recounting the actual event. And the defense here really wants the jury to be a bit suspect in terms of her credibility. They're adding the affair in to maybe chip away at her credibility, but as far as the event goes, that's everything, right? If the defense can get the jury to believe there's reasonable doubt, assuming Dr. Konig takes the stand, which he likely will, then it's all about the syringe, and no, I was going to push you off the cliff, which Ariel basically testified to. Then you have a different case. The X factor is the eyewitnesses. And those are the ones that called 911. And when they called 911, they didn't say, there's a man attacking a woman. No, they said to the 911 operator, there's a man trying to kill a woman. Big difference. Take a listen.
There's a man trying to kill her. She's blood all over her face. Where is this at? Polypuka, the hike at the lookout. Okay, so Poly lookout. She's on the Polypuka hike, and he's currently attacking her. Okay, where? How far is the hike, or is it in the entrance? Where? We're probably like 5 minutes into the hike. Really quick in. Okay, what are you seeing? We heard her screaming, help, help, help me, and then we saw a man over her, and then she crawled out with blood over her face, saying that he's trying to kill her. And did she know him? I don't know.
All right, Kelly Hyman can now hear us again. Kelly, this is the he said, she said with two other people that also say that they saw this attack. And the way they characterized it, not only on that 911 call, but in the courtroom on the first day of testimony, was that from their view, he was trying to kill her, and a rock is a deadly weapon.
Powerful statement. I mean, that audio, listening to that's firsthand of them coming up and seeing what exactly happened. And those statements are really, really powerful for the jury. That helps the prosecution's case because, Ted, as you know, the prosecution has the burden and they have to prove the case beyond a reasonable doubt. And that is pretty powerful statements from people who come up and see this and say what exactly they saw and believe was going on at that moment.
And healthcare professionals, too, that were on this hike. they worked together, which probably adds credibility in terms of the jurors' view of them. They were very polished in their descriptions of what they saw, and they both independently testified to this. And then you had the body camera video. This is a still from that. It's pretty evident she was hit on the head with a rock, and the defense isn't refuting that. What can he say, Kelly, if you were representing the doctor? I mean, he does have to take the stand, doesn't he? Depending on, of course, what his son says. But at this point, after Ariel, one would think he needs another version of events.
He needs to help substantiate the fact from the defendant's standpoint that he did not have the intent, because this is an intent crime. Did, in fact, he have the intent? Now, an attorney can advise a client whether or not they need to testify and whether they think it's a good idea. But Ted, to your point, if he's saying that this is just a he said, she said, then maybe it might be in his best interest to say, no, I did not have the intent to do this. We had a fight, and tell his side of the story. And then ultimately, the jury will weigh the credibility of the healthcare providers that saw this, the wife, and the defendant as well, and see who, in fact, they believe, and then render their verdict accordingly.
Yesterday, the attorneys all met in the afternoon, 8 o'clock evening Eastern time, but it was 3 in the afternoon there, roughly. And they hashed out this motion to suppress. Basically, the defense doesn't want the jury to know. And when they do reconvene, there's going to be a witness on the stand talking about this, because the judge says it can come in. It was a search of the doctor's digital footprint, which showed that he purchased a secret recording device. And this is in the midst of his marital issues, where he's found out about Mr. Miller, and he believes that she's having an affair. The defense wants the affair to sort of weirdly help them. I'm not sure if it does, because if a man is angry and is angry that his wife's having an affair, and he's gone to the level of buying a secret recorder to eavesdrop on her, that does, correct me if I'm wrong, that seems to me show a bit of instability to the point where now you could believe that he could get to the end of his rope on that trail.
Well, I think the counter argument to that, Ted, is the fact that if she was having this alleged affair, that it helps substantiate the fact that she wanted out, that she was potentially the aggressor, that she started this fight, right? That helps establish their position for the fact that maybe that she wanted out of this relationship, and also the fact that she allegedly moved some money as well. So they're kind of using it as, in fact, that she did have this alleged affair, and because of the affair, that she wanted out. So it helps substantiate their case. Now, Ted, to your point, you bring up really good points for the possibility that it helps the prosecution case as well.
Yeah, and that's why the defense didn't want the recording device information let in, and they fought so hard for it to be suppressed. The judge did rule that it will come in. We expect it to come in as soon as they convene today. On that note, let's slip in a break now. So as soon as the judge takes the bench, we can sneak into the courtroom there in Honolulu and pick up day 6 of testimony in the case against Dr. Gerhardt Konig. Stay with us.